Good morning, everybody. Very warm welcome to the session on fundamental constitutional principles. It is a great pleasure and an honor to host the session. I'm Takis Tridimas from King's College, and we have a very eminent panel here with us today. Allow me to introduce the panel by the way the members appear, at least on my screen. We have Professor Schiara, who is a judge at the Italian Constitutional Court. She's also Emeritus Professor of Labor Law at the University of Florence. We have Professor Wojciech, who is Professor at the University of Krakow and a judge in Strasbourg at the European Court of Human Rights. We have a Professor Alison Young, who holds the Sir David Williams Professorship of Public Law at the University of Cambridge. And we have also Professor Laurent Pech, who is the head of the Law and Politics Department at Middlesex University, with an enormous presence in the study of the rule of law. So what I was going to do is speak to the project for 2 or 3 minutes, explain the papers that we have uploaded, float some questions, and then pass the floor to the panelists. So this is a project under the auspices of the European Law Institute on fundamental constitutional principles. And essentially what we seek to do is to identify and articulate the fundamental constitutional principles which form the foundations of a European liberal democratic state. So what the project seeks to do is to encapsulate, if you wish, the elements of the European constitutional identity, the constitutional DNA of Europe, if I can put it this way. So we are making some assumptions. We assume that such a polity is based on the majoritarian rule, but it is also constrained by the obligation to respect the rule of law, including the protection of fundamental rights. So the idea is to lead to the formulation of those principles, identify the content, and provide guidance to public authorities, the courts, and civil society. The outcome of the project, therefore, is going to be a statement of principles accompanied by an annex, probably in the form of a checklist similar to that other projects, for example, the Venice Commission, have provided. Similar, that is to say, in style, in methodology. So the principles that we will cover include democracy, the rule of law, the separation of powers, the right to judicial protection, accountability, and fundamental rights as a component of the liberal democratic state. We are not going to be looking specifically at all fundamental rights. So why a project like this? First, I think it is of practical value. The case law, the growing case law of the European Court of Justice on the rule of law provides testament to the practical value of this discussion. Secondly, I think it is correct to say that Europe as a whole faces successive challenges. These include financial a crisis, the migration crisis, populism, and now health crisis. And I think it is good to be reminded of the constitutional fundamentals. There are many contemporary challenges to the rule of law and to constitutionalism more generally. These arise, for example, from technological growth, artificial intelligence, the role of social media, and so on and so forth. Although these developments give rise to problems in specific areas of law, what we are looking at is the underlying building blocks, what holds the whole thing together. We also hope that perhaps this project will serve as an umbrella project and spearhead more projects in specific areas. What we have circulated is a description of the project, also a feasibility study. This focuses on judicial independence, which will be an aspect of the rule of law. It is very much in draft form, but gives an indication of how we intend to go about each of those principles that will be the subject matter of the research. I was not intending to go through the feasibility study. I'm very happy to answer any questions, or try and answer any questions that there may be. What I was going to do rather is identify certain themes that run through this project. And I would say there are 3 or 4 of them. The first one goes to the heart of the rule of law, and it is what I call the Antigone and Creon dilemma. Is the rule of law, should it be understood merely as a process constraint, or should it be understood as including also commitment to certain substantive values? And if so, how do we select them? Second is what I would call the European Union aspect of this. What is the added value of European Union law on constitutionalism, on the rule of law, and how is the EU intervention in the area perceived by the member states and by other actors such as the European Court of Human Rights. How does the obligation to respect the EU version of the rule of law square with the national identity, respect for national identity? And more specifically, what is the added value of using the term rule of law in Article 2 of the Treaty on European Union? Is this an additional normative constraint, additional, that is to say, to the Charter or to the general principles of law? So there is a host of EU questions. There is a third aspect, which is more broadly what I would call a European aspect. And this is the following: is there something distinctly European about the fundamental constitutional principles we will be discussing? Distinctly European as opposed, for example, to the American version of constitutionalism, or the version of constitutionalism endorsed by other Western systems. Also, how does the common law civilian distinction influence the quest for and the identification for the fundamental constitutional principles? And finally, I think there is an international law aspect. Do we define constitutionalism only by reference to a sovereign, or do we include extraneous sources? Do we posit that the rule of law includes not only respect for international law, but also a respect for certain principles which national law must include? In other words, principles in relation to which sovereigns do not have a choice. The papers that we have included, I think, try to capture this discussion. You have a description of the project, you have the feasibility study, very short paper discussing Article 2 of the Treaty on European Union, and a host of papers from the very ambitious and excellent project that Professor Pech has introduced. May I also say that from all the panelists, I am by far the least knowledgeable about issues of constitutionality and the rule of law. So if I can pass then the floor to our panelists to comment, and maybe I can do it in the order that I mentioned earlier, in the order that the panelists appear in my screen. Maybe Judge Scara would like to say a word.
Thank you. Thank you very much. It is really a privilege to be in this webinar and to be chaired by Professor Tridimas, who is an authority in the field, among the many other fields in which he is an authority. And I just want to start from a sentence which I underlined in one of the papers that have been circulated, and emphasizes Article 2 in the treaty. And this brings me to say and anticipate what I think that we should, in this project, have a very specific European emphasis, or an emphasis on European law. And Article 2, says Professor Tridimas, has a signaling function. I like this expression. And I think it makes a statement of constitutional identity by declaring commitment to the founding principles. And it forces us all to bring consensus. I think that a project like this should really empower scholars and those who work in ELI projects to help us lawyers in different capacities to create and build up consensus around fundamental principles. And I think ELI's role should be underlined in this tragic time of history when we are all looking around for directions, guides, and I anticipate immediately an answer to one of the many questions. I won't be able to reply to all of them that our chair put to us. In my view, the rule of law inevitably brings together the substantial and the procedural side of the issues, which means, in my view, that procedures imply entitlements and guarantees, and they go directly to substance. So what I would like to see out of this project is that we empower individuals as well as public authorities, civil society, or courts, empower individuals and make it clear to them how they can challenge principles which are not in line with what we think should be the fundamental principles. Hence, I think the project should clarify this link, substantial and procedural sides. However, let me clarify, because I think when there is a discussion, it's useful to put forward some not really critical points, but perhaps some tensions that I have sort of seen in the project, looking at the project, because this is a very ambitious project, therefore it is a very interesting project. In 40 pages, we should receive all the incredible information that you were anticipating before. And I find the first tension in the language used when you say descriptive and prescriptive. Descriptive, I imagine, is the comparative analysis, and as you mentioned before, we have impressive amount of work in the field. And nevertheless, we would need to know what kind of methodology in the descriptive side you are going to adopt. And what about the prescriptive side? How can it be? Because we are here, as in ELI's tradition, indicating sort of soft guidelines. So this prescriptive is indications to the addressees you mentioned before. But then what challenged me are the challenges that you mentioned in the project. For example, among contemporary challenges, you mentioned sustainability. Sustainability, is it a mere objective that we are going to propose, or you are going to propose in the project? Is it an optimal behavior that we ask to companies, to states? For example, should we say that this can be favored by fiscal incentives? And how does this link with the rule of law? And the other challenge can be for artificial intelligence, which is a challenge we all feel so urgent in judicial matters as well. And so perhaps I think that should have a focus of its own, a very strong focus. And finally, the tension I see in the target outcomes, because I appreciate the targets you indicated before, but don't you think that the addressees of such a project could be, and this is probably in ELI's original mission, the target should also be to disseminate wisdom as well as principles among practitioners. And so how could, in writing the target outcomes, which I see are still uncertain in the papers I read, if this objective could be central and should be strengthened, how could we empower individuals and therefore practitioners? If there is time, I can give you a couple of examples that I have in my reading. And by the way, all very interesting papers. Thank you for sending them all over. Some uncertain points. For example, the traditional approach to the rule of law, case law or supranational courts, and then a window of opportunities on more, so to say, crucial issues is open, and this is judicial independence in the digital era. I would definitely privilege this side and therefore add something new to the vast amount of research and papers that, I would really, in the feasibility study, sort of magnify this point if possible. And then when it comes to indicate, this is again something I've read in the proposal, a minimum set of rights and processes to identify the concept of constitutional democracy. Perhaps couldn't we set the research agenda somehow differently and looking at ways in which constitutional rights should be guaranteed? I'm sure this is implied in what you say in the proposal, but this is very important for me. How should constitutional rights be guaranteed? I have in mind some experiments that have been made, for example, in transposing European law into national law, of the ex-ante approach, whenever we need to know what shouldn't be really touched. Of course, I have in mind the experience of the austerity measures, and I have in mind the tragic situation in Greece. But that's not the only point. I think research on the Polish case is instructive when we move to the case law, and it is interesting to see how both the Advocate General and the Grand Chamber in the famous case underline the tribunal established by law. And this point in the court's decision, I think, should also be a guiding point for us when we move to the analysis of the case law, which I understand is crucial and very central in the project. I would stop here if you like, and perhaps answer other questions later. But let me say that really I have enjoyed reading the papers, and I think this should be of incredible help to the academic. Oh, my paper was dropped on the floor. And perhaps I see a very interesting link, if I may add just my personal opinion, to the recent principles on COVID-19, which ELI has disseminated. I wonder how the tragic time we're going through could be sort of exemplified even better in the final version of the project and in the final outcome that I'm so eager to read. Thank you.
My apologies. Thank you very, very much, Professor Schiara. That was extremely helpful. And I will come back to try and answer at least some of them, some of your points later on. Judge Wojcik, it's an honor to have you.
Thank you very much, Professor Tridimas. It's a great pleasure and a great honor to be here. I would like to make a few comments about the project, which I find very interesting and very promising. I think that when we speak about the fundamental constitutional principles, the point of departure should be to reflect on the question which principles are listed as fundamental in the different states. The list may vary from one state to another. And then there is a second point, which also deserves reflection. That's the fact that the principles which have a similar wording may be understood to some extent differently in the different states. I will give you just one example: a rule of law, a British and English concept, and Rechtsstaat which is much more widely accepted in Central and Eastern Europe. There are some subtle differences between the two. So it would be very interesting to reflect about which principles have to be listed as fundamental and how these principles are understood and what are the differences. It's very important to identify the differences in the understanding of the principles throughout Europe. This is my first point. Now, the second point, as Professor Tridimas mentioned, there is a very rich international law, hard law and soft law on the issue of good government, let's call it this way. There are the international covenants on human rights, which regulate certain issues concerning constitutional structures. There is a very extensive case law of the Council of Europe, and there are quite detailed recommendations of the Venice Commission. We have different documents of the OSCE. We have also documents emanating from some non-governmental organizations, and especially International Commission of Jurists. So it would be also very interesting to reflect about, in the context of this richness of hard and soft law sources of international law, what should we do with all this? What should we retain, accept as fundamental, and what is less important and maybe perhaps set aside? But we have a very dense corpus of soft or hard rules regulating constitutional matters at the international level, and this is a corpus of rules to which the European Court of Human Rights refers quite often when it has to deal with issues involving constitutional matters. Then my third point, I would like also to note that constitutional principles may sometimes collide. We had a very interesting case quite recently at the European Court of Human Rights, Mongemango versus Belgium, in which we had to face a collision of two principles, parliamentary autonomy and access to courts. And we had to reconcile both the parliamentary autonomy and the necessity of effective remedies in electoral matters. And this is also linked with the question of exceptions to principles. To which extent, for instance, can we allow exceptions to the access of courts? Are there any non-justiciable issues which should be taken away from the court's agenda? In some countries, it is considered, for instance, that electoral disputes have to be adjudicated by the parliament itself and not by the judge. And this is only one example among others. So we have to reflect about the articulation of the different principles, the possible collisions, and how far we go when we propose some trade-offs, how to solve the possible conflicts between the different principles. And my fourth point, the states, nation states, are now just one among many holders of public power. There are international organizations, there are non-governmental organizations which aspire to exercise power in the different fields of social life. The question is, do we devise principles which will apply only to nation states, or do we reflect about maybe more general principles which may be applicable to any structures which aspire to exercise public power? Can these principles be applicable to the EU itself, and to which extent what's proposed in respect of nation state may be relevant for a supranational organization? To which extent do we also reflect about delegation of public power to private bodies, non-governmental organizations? This is also one of the challenges to the rule of law and constitutional democracy we have to face. If sport, international sport, is regulated by unelected bodies, is this an issue in a democratic state? Well, the question is maybe not obvious, but at least it deserves consideration. And there are much more examples of private bodies which regulate the internet or other important spheres of social life. So do we also reflect about this issue of articulation between nation states and other structures which exercise public power and which do not necessarily have a constitution and which do not necessarily grant all the rights they should grant to those who are under the power of all those structures which aspire to exercise power. So these are the reflections which I wanted to come today. The issues we will have to discuss, taking into account that if throughout Europe, basically, we agree about the principles as such, we do not necessarily agree about certain details and the way the principles are implemented, as this recent Belgian case, Mungemango versus Belgium, examined by the European Court of Human Rights, shows. So certain principles and the exception to the principles are an object of quite acute disputes. And this is also a parameter which we have to have in mind. Thank you. Thank you very much.
Thank you very, very much, Professor Wojciech. That was these are brilliant thoughts. I am aware of time, so we go straight to Professor Young. Alison.
Thank you also very much for inviting me to what is a very fascinating and worthwhile project, and for the documents you've sent. A number of the points that I was hoping to raise have already been raised so well by both Professor Sciarra and Judge Wojciech, so I would focus on some additional points, but just to reinforce that I think it is very important for this project to think carefully about the application of judicial independence in the digital era. I also think it's very important to build on specific principles that apply the rule of law to private bodies that have public power, to private bodies performing regulatory functions. And as we're seeing a growing number of, particularly in the United Kingdom, a system of hollowing out of the state, where powers to make binding guidelines are then passed on to private bodies rather than public bodies. And I think it's very important in those circumstances to think of how far these guiding principles of the rule of law can apply both to these private bodies that are performing regulatory functions and also that are performing these kind of almost quasi rulemaking functions in certain circumstances. And I think it's particularly important in the digital era to think about how these principles interact not just with promoting rule of law, but also with the ability of upholding democracy and certain systems, and how far the digital era needs principles to ensure that, particularly when it comes to elections, there is an ability for information to be shared, but not in a way that can undermine the democratic process. And I think all of these are very important elements. Having said those points, I think I'd also like to stress how important this process is. So, coming from the UK, I cannot ignore the events of this week, where we have statements in Parliament of Ministers saying that they are going to enact laws and empower ministers to act in a way that can disregard international obligations, and also accompanied with an ability of the courts to not be able to say that regulations are unlawful because they've breached these particular international obligations. And I think it is stressing the importance of your point that the rule of law is also important in terms of upholding principles of international law, and that as much as we have an EU community, the EU is part of the international community, the member states are part of the European Union, and the member states are also part of the international community. And I think that dimension is very important as well to stress. Turning to some of your themes, I think the reason we often dispute whether we think the rule of law is purely about process or is purely substantive is because we're getting tied down by thinking of the rule of law as a purely legal concept, either as a purely legal principle to be enforced by the courts, or as something that we understand as lawyers, as a purely legal concept. And I think what is very important about your project is it's recognizing that the rule of law also is a principle of good governance. It's an aspect of it has a political dimension to it. And particularly when we think about that political dimension, I think that's when we can think very importantly about the need to focus on substantive principles. And I think this connects into your point about the signaling function of Article 2 of the TEU. It's very important to be able to say, well, we've come together, we agree to these principles, and to have this element of consensus building that shares these fundamental principles, but also is sensitive to and recognizes that in those areas where principles contradict, there is an ability for leeway for member states to express their cultural preferences of how to balance these competing principles. It's not an easy job to do. It's a very difficult task, but I think it's a very important task. And I think it's something that is very important for this project to be focusing on. And I think my final brief point would be to focus on not just seeing this as something that's important for institutions, something that's important for practitioners, but I think it's important for all of the citizens involved in European projects and citizens in different member states. I think it's important to disseminate these principles down to everybody, because then you're not in a position where individuals think that somehow sovereignty is more important, these fundamental principles. If these fundamental principles are accepted and become part of the culture and are disseminated down to everybody, then I think there's a much better way of shoring them up through having them part of the culture, as well as having them as part of these principles that guide individuals. So I'd really encourage this project to focus on disseminating its information in a way that is accessible to all, as well as accessible to practitioners. So just to reiterate, I think it's a really interesting and wonderful project, and thank you very much for asking me to make these contributions.
Thank you very, very much, Alison. That was, these are extremely valuable ideas, and thank you for engaging. Professor Peck, Laurent, please.
Good morning, everyone, and thank you for having me this morning. Rather than starting with some comments on the project itself, perhaps I would like to just give you my understanding of what is the greatest challenge now regarding the rule of law in the European legal space, and tell you about the work we've been doing within the framework of the Reconnect project, and then see possibly link what we've done with what you're planning to do within the framework of this project. So in terms of what is the greatest challenge these days regarding the rule of law, but I guess we could say the greatest challenge to EU values, European constitutional values. I have called this challenge rule of law backsliding, but you could also describe it as democratic and rule of law backsliding. So what do I mean by a rule of law backsliding? Essentially, this kind of a new threat to the rule of law first emerged about 10 years ago, following the re-election of Orban in Hungary. In practical terms, what does it mean? It means the deliberate dismantlement of all checks and balances on the basis of a blueprint. So this is what is so frightening, if you don't mind me saying, about this challenge to the rule of law, is this is a top-down dismantlement of the rule of law based on a plan, a step-by-step blueprint, which always begins with the same first step, which is the capture of the top courts of the relevant legal system, followed by the capture of the public broadcaster. Why would you want to capture the public broadcaster at the same time you're capturing the courts? Because then you can shape the narrative and explain that in fact you're destroying the rule of law in order to save the rule of law. Once you have captured the courts, then you can dismantle all the checks and balances which remain. So you capture, for instance, regulatory bodies, and then you use this capture regulatory bodies to undermine political opposition. When this process is completed, essentially, you no longer have free and fair elections. The system is entirely captured, and you end up with an authoritarian regime. Political scientists speak of electoral autocracies. Hungary has been labeled the EU's first authoritarian state by the VDEM, so a network of democracy experts last year. So the EU has its first non-democratic regime in 2020. It has been described as an electoral autocracy. Now, this process has a conceptual dimension, which is new. When I started working on rule of law backsliding, there was no already impact on the conceptual plane, but this has been changing in the past 4 or 5 years. So much so that the latest project of the Hungarian government is to invest, in fact, into a new network of V4 academics, which would then be, I guess, a task to spread the autocratic gospel. Now, in terms of the rule of law, what kind of work we've been doing with the Reconnect project? In fact, we're both working on the conceptual plane and the practical plane. In fact, my most recent work has been to deal with the conceptual criticism originating from these autocratic governments of Poland and Hungary mostly. In terms of the concrete manifestations of this conceptual challenge to the rule of law, I mean, it has plenty of different aspects. So because my time is limited, I'm just going to oversimplify and just give you some concrete examples of how it works. So one of the key aspects of this conceptual challenge to the rule of law, or at least the way the Court of Justice and the European Court of Human Rights understand the concept, is to deny that there is a common understanding of the rule of law in Europe. So yes, there has been many disputes about the scope, the meaning and the scope of the rule of law, but here you deny completely the existence of a common understanding. And in fact, I would argue this is completely false. And this is, in fact, the first Reconnect deliverable we published a few months ago, but unity, diversity, and the national understandings of the rule of law, where we show quite clearly and convincingly, I would argue, that there is a core meaning of the rule of law. There is no such thing as an East-West divide when it comes to the core meaning. But this is what's happening. They also deny that there is a set of common minimum standards regarding the judicial branch. So the argument is essentially we can do whatever we want with the organization of a national judiciary because we don't have common standards. For instance, there is no such thing as judicial independence according to some governments. Why? Because first of all, judicial independence is not mentioned or defined in the EU treaties or the Council of Europe treaties. I'm just describing here. This is obviously not my view. But this is one aspect of the conceptual challenges. There is also a denial of any supranational role for the European institutions on the basis mostly of an abusive use of the constitutional identity, constitutional pluralism argument. So I have also written on this, especially I would recommend the reading of the so-called white paper on judicial reform published by the Polish government. It is just out of this world, but it's very important to read it. It's from March 2018. And they point blank use the concept of constitutional pluralism, and they rely even on distinguished scholarship to argue that they don't have to comply with the European understanding of the rule of law. First, because there is no such thing, and two, in fact, they're entitled to on the basis of this concept of constitutional identity / concept of constitutional pluralism. Another striking aspect is the misuse, abusive use of comparative law. So what we're seeing is national governments keen on destroying the rule of law. What they do, they look around for worst practices. They don't look around for the best practices. A colleague of mine, Professor Shepelet, has referred to this process, the Frankensteinization of the state, essentially. You look around, you look at Spain, you look at France. Most of the time, actually, they misrepresent foreign law as well. So just to give you an example, the Polish muzzle law was supposedly based on French law. I destroyed completely this abusive use, in fact, a misrepresentation of French law a few months ago, along with some French law colleagues. But since most people don't know, obviously, about French law in the Polish legal system, then it's a good argument to use when you try to dismantle checks and balances. And then another aspect, just because my time is limited, the use of the will of the people argument. So you see more and more conceptually speaking, the use of the will of the people, also the concept of social justice, intriguingly, has been used by the Polish president to justify exceptions, restrictions on rule of law / judicial independence. So that's quite new. I saw the concept of social justice being used to undermine the rule of law last year for the first time. It didn't really, I didn't spot it before. Now, all of these essentially conceptual challenges to the rule of law, we're dealing with them within the framework of this RoConnect project. I can circulate some of the papers with the participants listening to this workshop using the chat function. But essentially, as you could guess, I don't believe in any of these conceptual challenges. I think they are not simply, in fact, guided by, not based on honest description or even overview of the legal systems and the case law as it exists today, but it's important to take into account. Now, coming back to the U project, I think it's important possibly, I mean, this is a very promising, very ambitious project, but my first concern would be possibly that it is too ambitious, especially can you really do within 40-page a statement of the 6 principles you have distinguished. I know it's a provisional plan. I would say also possibly there is more work to be done regarding the 6 principles you have identified, because possibly it might be easier just to begin with democracy, the rule of law and fundamental rights, and then look at the subcomponents of each. Because for instance, you have distinguished the right to judicial protection, but this is clearly one of the core components of the rule of law. So I'm not sure why you would want a separate statement of principles regarding this aspect. Possibly also, you may wish to reflect a bit more on the potential added value of the work you're contemplating. Possibly, in fact, what would be the key added value of what you have in mind would be to condense, summarize all of the work which has already been done. So possibly the danger to avoid is to reinvent the wheel when in fact there is a lot of studies, a lot of research already been done. You did carefully, obviously, refer to the work of the Venice Commission. True, on the rule of law, for instance, I think you don't really have to do much research. You just have to summarize what is out there. Regarding democracy and human rights, there is also a lot of work which has been done. I'm thinking here about the book by Professor Albi, National Constitutions in Europe from 2019, which offers about 32 national reports discussing the meaning of the rule of law, democracy, human rights, but also separation of power in at least 32 countries. I think so, 27 EU member states plus a number of non-EU member states. So possibly to make your life easier, and in fact, to bring added value, you may wish to more or less condense and see possibly where the gaps are in the existing literature. But to do all of this in 40 pages would be quite an achievement. So possibly, therefore, it may be wiser just to stick to democracy, the rule of law, human rights, and to look at the meaning and scope of these 3 principles and to try to see whether you can distill the core meaning, the core components of all of these values, and then on this basis, then you can present them as the core minimum of the European constitutional DNA as you wish to do. So this would be my comments for today.
Thank you very much. Look, this is extremely valuable, and I'm really enormously grateful to all the panelists. I'm aware of time. I don't think I have time to, if I can answer in one word all your comments, is to remind myself of the ancient Greek motto that ignorance breeds arrogance, but knowledge brings complacency. And I think I'm now in the stage of having more knowledge as a result of your comments and resisting complacency. But it is absolutely wonderful to have these comments. May I open the floor for discussion? I understand that questions can be placed by the audience via the Q&A function, or maybe some of them have, at the moment I don't see any open questions. While we wait for them, there is...
just me sharing some references. I'm just going to share a link to the book by Professor Albi, which is very good. And I think there is another volume coming up soon. Sorry for interrupting.
Not at all. No, thank you. Thank you. And that is, of course, yes. I think Annelies' book is an extremely good source. You're right. I'm aware of it, but it is always good to be reminded. I appreciate all your comments. I'm aware of the difficulties. I'm also aware that it is very difficult to compromise all the different tensions. On the one hand, we want to have added value, venture into areas that have not been covered by existing reports or literature, embrace challenges to the rule of law that arise from contemporary developments. On the other hand, we don't want to be too prescriptive. There are many different ways of complying with the rule of law. There are many different ways of observing fundamental constitutional values, and one needs to somehow make sure that avoids being over prescriptive while at the same time being useful. I'm keeping an eye on the questions. If I can just pick up some of the points, I think Lauren's suggestion that maybe we should only concentrate on democracy, the rule of law, and fundamental rights is a wise one. Of course, many of these principes that we have outlined are overlapping. So by focusing on the rule of law, we inevitably would need to deal with some of the more specific principles that I have outlined there. I hear what the panel said about getting into substantive elements and not just procedural elements. I hear what you're saying about observance of international standards. I hear what Judge Wojcik said about balancing and how difficult it is to be done. And I also registered the point that consensus building is something which is politically important and where the project would have some value. And I also hear what you say about reaching the individual, reaching practitioners. I cannot promise we can do all that, but I can certainly promise that we will try. I see a question here. Yes, and we have a very helpful comment by Duncan Fairgrieve, who I think he asks, are we envisaging a restatement of fundamental constitutional principles, drawing upon pre-existing ones? And the answer to that is yes. I think that's what we are envisaging, at least in part. Professor Schiara raised an issue, related issue here when she said, what is our methodology? How do we do the descriptive part? We don't intend to have a thorough comparative analysis of the laws of the member states. I don't think it is feasible within the timetable. So inevitably, we would need to rely on secondary literature, for example, Professor Albi's book, and there are many books that look at various aspects. There are other projects within the European Law Institute that look, for example, there's a project that looks into common constitutional traditions, and it looks selectively at certain rights. We will be, I think, informing ourselves from their analysis. But the idea is really not to do an open-ended comparative research. I don't think we will be able to do it. It wouldn't be practical. So we are looking for a synthesis. We rely on the case law of supranational courts. We rely on literature. We rely on international reports. And we are also, we have a number of researchers. We are also looking at national law from primary sources. But I don't think it is possible to look at all the national constitutions. Yes, also I'm alerted to the fact that the methodology used by the Council of Europe is helpful, and indeed the rule of law project of the Council of Europe does have a wealth of comparative analysis there, yes. Thank you. Anything else? If there are no more questions, while we are waiting for questions from the audience, yes, Professor Wojcik, please.
If I may, I just wanted to ask the question whether the principle of separation of powers should also be taken on board as a separate principle, or is this considered to be part of the rule of law? What do we do with this? Because it's a principle which is really fundamental, and it is more and more developed and referred to also in the Strasbourg case law, and it has traditionally been considered as the first protection of the citizen against the arbitrariness of the power. So we also reflect upon this principle.
Yes, this is extremely helpful. Thank you. And it is certainly, it is a question of how one goes about addressing these principles. In other words, whether we have a specific section on separation of powers, or whether this is encompassed under, for example, judicial independence, under a political accountability, and democracy, and the implications for democracy, for the partition of competencies between the executive and the legislature. So we will certainly look at it. It's a matter of how it is best and in what context it is presented. I mean, Duncan Fairgrieve again helpfully says separation of powers is very culture specific, and there's a specific perception of it in France that's very helpful. Alison, did you want to say something?
Thank you. Just to reiterate that I think it is important to focus on the separation of powers. I think Duncan Fairgrieve is absolutely right to recognise it is very culturally specific, but underpinning that there are understandings of the needs, however we structure our society, for effective checks and balances. And I think whilst we can see effective checks and balances linking into the rule of law when we're thinking about judicial controls, I think it's also very important to understand that within political systems, there need to be effective political checks and balances as well. And I think that's where aspects of checks and balances and separation of power can separate out from the rule of law. So it might be worth thinking about both these political and these legal checks over executive powers.
Thank you. That's very helpful, Alison. The truth is, I haven't focused so far on that aspect, but this is very helpful.
Question? I'm sorry that I don't know how to raise my hand. I was used to another platform and I don't know how to raise my hand, but if there is a minute, I wanted to ask another question.
Mm-hmm.
Sure. I mean, the other point which was not so clear to me in the project, and I think it's incredibly useful to sort of clarify once you decide how to select the various issues to be dealt with, is when you have a chapter on other principles, which seem to be principles complementary to the fundamental principles you're choosing as the core side of your project. And there you have equality and dignity, which is again a huge field that you should consider perhaps how to reconceptualize within the principles on the rule of law. Because here I see that you say we still have to decide whether to include equality and dignity. And then you say that the project, and you actually mentioned this again today, will not focus on specific fundamental rights. So in a sense, what I found very interesting, just from my own thinking, is how do you combine these two options and how you select other fundamental principles which are, so to say, useful or maybe necessary to complete the general framework of the project. Thank you.
Yes, thank you. It's a very legitimate question, and the answer, how do we make the distinction? The honest answer is with difficulty. I suppose one can identify a number of fundamental rights which are an integral part of the rule of law, and we are not going to look at them. For example, the freedom of expression, or freedom of assembly, or the right to security in the strict sense of due process. The equality and dignity have a transversal character, which might justify the separate treatment. I think a lot depends on time. I think a lot depends on what how the members of the group feel it's best to proceed, and frankly also a lot depends on the feedback that we get. So that is why we would very much like to have a series of these web seminars, test our ideas, and I think then a consensus will emerge as to what the community feels that is missing, or the community feels should not be in the project. So the answer is yes. It is a difficult challenge, and I appreciate that it is not clear in the description, or at least it's not quite yet settled. Let me address a few questions which are now coming in. I'm aware of the time. Mark Clough, you see, asks if we are going to look at the relationship between the European Court of Justice and the European Court of Human Rights. It may be too specific. I think we don't want this to be an EU project. We'd like to look at it more broadly, but of course, looking more broadly, one encounters the question of the relationship between the two courts. Sir Jeffrey is passing his thanks, and I think we are grateful to him for leading together with Francis Jacobs the project. There is a very interesting specific question about the impact of the ECJ judgment on Polish judges. I think that's the judgment of November 2019. Okay, and there is also a emphasis on the need to have a more focused project, which is fair. Yes, I entirely appreciate and value the questions. I think we've reached the end of our time, and I wouldn't want to try the patience of the audience, or indeed the panel. All I would like to say is we would have a look at all the questions that come. We are enormously grateful, and I'm extremely grateful to all the panelists, and very honored that they spend their time on this. Thank you very much.